All right, so let's return to our discussion of 404B and how you can get around the character evidence proscription found in 404A. And to continue that discussion, we're going to go meta here. We're going to actually, while they're taping us, we're going to go to a videotape. So we'll play, in fact the whole class is just going to be me playing video clips. So, all right? Do a little experimental thing here. No, the first clip, we're going to actually, I think the only clip we'll see, is a clip from the Presumed Innocent movie, which some of you may have seen, where Harrison Ford is a prosecuting attorney who is on trial for supposedly murdering one of his female colleagues from within the office. And the clip we're going to see is where the prosecuting attorney is trying to put on a witness to testify about whether or not Harrison Ford, who is married, but not to the dead person who's now dead, whether or not Harrison Ford had an affair with the female who is now dead. Okay? So we'll have Mr. Richards, you will be for the defense here, and Ms. Ulmer, you'll be for the prosecution here. So Ulmer, I'll ask you in a minute, what's the right objection here? You're going to hear a terrible objection, so you're going to have to come up with a better one, okay? If I can find this clip here.
I got the feeling he was stalling. He brought in his own detective to replace Harold Greer. And then he gave this new partner of his instructions to ignore evidence about telephone calls between his house and Carolyn's. He tried to limit the scope of the fingerprint search so as to exclude his own. He seemed much more interested in whether I had been intimate with Carolyn Polymus than in the facts surrounding her murder.
And what did you tell him about you and Miss Polymus?
I told him the truth. We'd been together for about 3 months. This, of course, was after I was divorced.
At that time, or any other time, did Mr. Savage inform you that he had a personal relationship?
Objection. There is no proof in the record of any relationship between the defendant and Miss Polymus.
Well, I'm going to let the question stand.
All right. Bonnie Bedelia is Harrison Ford's wife, who's just finding out about the possible affair. That's why they cut to her. And so obviously Harrison Ford must kill this woman after he finds out that she's also sleeping with Brian Dennehy, because he would be so embarrassed if she told. Or that could be one theory, right? But they have Dennehy, who is another attorney in the office, on the stand, who's about to testify to a supposed affair from between Harrison Ford and the dead woman. The objection, there's no evidence in the record of an affair. Why is that a silly objection?
Because that's what he's asking.
Yeah, that's the whole point of this evidence, right? So what would a better objection be, Mr. Defense Lawyer, to this evidence?
Well, that this is impermissible character evidence, that there's, basically that this is evidence of another act.
It's not opinion or reputation evidence.
Sorry?
It's not opinion. He's not giving his opinion that Harrison Ford is an adulterer.
Right. But it would be an act, right?
Right. Yeah. I think adultery is an act.
Yeah.
Right. And you're saying they want to use it, or it will be used by the jury to draw a negative character inference about Harrison Ford.
Right. That he's a bad person.
Right. He's the kind who doesn't honor his marriage vows, so of course he must also not honor homicide law.
Right.
Right? And what do you say to that, Ms. Ulmer, representing Harrison Ford?
If I were representing him, I'd probably say that you were trying to prove like
I'm sorry, I got you in the prosecution, don't I?
Yeah.
Okay, so there may be a better argument that he didn't give us, but you give us the response for the prosecution now as to why you think it should get in.
Why we should let the evidence?
Yeah.
Because it would just probably show like maybe a reasoning or some premeditation to why he murdered her. Or like some sort of like a motive of like.
A motive? What's your reasoning there? She's no longer going out with him, and she's going out with Brian Dennehy. So he
got jealous and upset.
And went to kill her. So it does supply some motive, arguably. Maybe, let's assume that she broke off the affair. Let's say it's going to come out that she broke off the affair and not him. Does that help your argument?
That she broke off the affair?
Yeah.
Yeah, because then it shows that he was still interested in having a relationship with her.
Right, right. What do you say to that, Mr. Richards?
I'd still argue, well, I guess I'd fall back to 403 then at that point. I'd say that at that point, the evidence is still substantially more prejudicial than probative. And it could possibly, could cause the jury to still rule on the basis of his character than on the motive. It's possible they'll disregard any instruction to take the evidence only for motive and just think this guy cheated on his wife and therefore he should be guilty.
So do you concede that motive is one way around the character evidence problem here? Do you think that Ulmer has articulated a proper 404B use of the evidence?
Under 404B2, you can use it for motive.
Right, so you're conceding that basically a broken off love affair or sexual relationship could provide a motive for someone to kill someone else.
Yeah, I think it certainly could be.
How much probative value does that have?
I guess if I'm the defense attorney, I'm going to argue it doesn't add enough, or the prejudicial value still substantially outweighs any probative value. Personally,
I hope you're going to make that argument.
Yeah. Personally, I feel like it's pretty strongly probative. I think it gives a reason that he would have for killing her, potentially.
Do you have any exes?
Yes.
Okay. I'm glad this is on tape. So you're saying, stepping out of your defense attorney's shoes, you think that a terminated love affair could give one a motive to harm the other?
I think it could. So.
Yeah, right. And Ulmer, do you agree with that? How much probative value do you think it has? Now step out of your prosecutor.
I still think it has probative value. I think it is instant motive for murder.
But we need to know how much. I guess, so what's the balancing here? Do you think that the risk of prejudice is sufficient here to outweigh that probative value?
I do. No. I think that the probative value outweighs the risk of prejudice.
Right. So you would say let it in.
Right.
You would let it in. Boy, I'm surprised. Every year we do this, and some years people are like, it's crazy. Affairs end all the time, relationships end all the time. This is the first time I think I've had two people say, I think I might kill someone if they broke off. Well, that's good to know. It's good to know. Is there another, but I think you're right, especially if we learned more about it. Maybe it was a really tempestuous affair. Maybe we would want to know more to really assess the probative value, and I know you're saying that, Richards. Let's hope. Is there another 404B use here? What if you're wanting to establish access or opportunity?
That's possible.
Yeah, especially, let's say it turned out that he had a key to her apartment because of this affair. That then is surely should come in there to, if she were murdered in her apartment, let's say. What?
Well, I don't think you need to know necessarily that they had an affair at that point. You could just say that he had a key.
Fair enough, but isn't that going to be, from an old chief narrative relevance standpoint, isn't the jury going to be saying, why did he have a key? Shouldn't the prosecution get to tell that?
I think so at that point. I think that at that point still, I think at that point you'd apply 403. I think that would be danger or unfair prejudice without weighing the value. Knowing why he had to keep. That's all that's being reduced for.
Could have been that they were on the same team prosecuting cases or something, and they worked out of her house a lot. Something like that, right?
Sure.
Yeah. But I think we would, again, I mean, as with all of these clips, we would need to know more information to really assess the proper uses and the probative value. But it does illustrate, and depending on the judge, I think they would probably, you could get a judge to agree with you that the mere fact of them having an affair could supply a motive for him to have done harm to her, or at least to have been angry at her. Right? And to maybe that led to some other series of events. Now, how much evidence, this is not the same question as Huddleston. How much evidence do you think the prosecuting attorney needed of there having actually been an affair before that question was asked? What if you're just fishing around? Could you ask that question?
I think you need a good faith basis to believe that there was an affair.
To even raise the question, and then if there's an objection under 404B, then we get to the Huddleston question, which we'll get to later. But you're right, that's absolutely right. The prosecutor or the attorney asking that other act question needs to have a good faith basis for it. You can't simply engage in innuendo through the questioning. Otherwise, you could simply drag someone's character through the mud by just making up, did you hear that Richard's X, Y, or Z, right? If we were on film, I would give more examples of these things. Right? So, now what about the lottery list problem 3.7, Ms. Ulmer? Here, the police have executed a search warrant. They found cocaine in baggies, as well as several pieces of paper with lottery numbers and lists of bets written on the paper. This is on page 159. At the trial of Mr. Jones disputes that he was the occupant of the apartment. Prosecution want to offer evidence of the papers showing what appear to be illegal lottery bets, like he was running a private lottery, and evidence that Jones had previously engaged in illegal commercial gambling 4 years earlier. Should this evidence be admitted in Mr. Jones' trial?
I would be hesitant for that as a fact. But
Well, what's the 404B use here? They're trying to establish under, or with this evidence that there were lottery slips found and that he had a prior gambling conviction. What are they trying to do with that evidence? Are they simply trying to say illegal gamblers are more likely to be drug dealers?
I think they're showing that has a greater likelihood from actually being the culprit in this crime.
Yeah, it's for an identity purpose. They're trying to establish that he was in fact the occupant of that apartment, right? And so what's the chain of inferences here?
That he'd been in like a similar situation previously, and for this, that he more than likely to be like in this apartment, so he was probably like the occupier of the apartment.
Right. So they find gambling paraphernalia and drug paraphernalia in the apartment. And they have, wow, they shot a gun in here. So they have the drug paraphernalia, the gambling paraphernalia, and they have evidence of a prior gambling conviction. So what's the inference they're trying to draw here from the prior gambling conviction? So they got the prior conviction, and we've got drug stuff and gambling stuff. Now obviously, if they were trying to say somebody who is convicted of any crime is more likely to be a drug dealer, is that permissible?
No.
No, and that's the charge at issue in the trial. That's not permissible. Then they're supposedly wanting to show, they want to link these two things together, don't they, to establish his identity as the occupant of the apartment, right? So, do we really have an impermissible character inference here? Well, not here. But what's the inference that links these two, the gambling slips found in the apartment and the prior gambling conviction? And what kind of inference is that? Yeah, that's a propensity inference. Now, it's not the one for the charge here in this case, but that seems to me to be just a flat-out character inference, right? So, while this is arguably a 404B use, identity to then establish that he was the drug dealer, but to get to this identity use under 404B, don't we have to make a 404A character inference about gambling propensity? Is that what 404A is? Is this the kind? So you could certainly argue, and some judges would buy, that is this inference is a propensity inference that's barred under 404A. Is that what we're trying to prevent, though, with 404A?
I don't think.
It certainly doesn't seem to be the core concern, because this is the core concern, where the other act will lead to character inferences about the civil claim at issue or the criminal charge at issue, right? And we don't have that here. So what's the argument that this isn't barred under 404A?
Is that it's just a totally different and separate occasion, and that, like I said, you need to have it under 404A in order to get to the identity involved, and so the purpose value is greater than the prejudicial value.
We've got to establish identity. Now, it seems improbable there aren't other ways to establish that he was the occupant of the apartment. And in a very important point, the court, in deciding whether something is admissible under 404B, should look at other ways of proving identity or whatever other use you're trying to make of the evidence. But let's say this is the only way they can link Jones to the apartment. So, how strong do you think the inference is 4 years, one gambling conviction to these slips? How strong an inference? How much probative value?
Personally,
Yeah,
I think it's
right.
a lot because of the length of time.
Right. Now, what if we knew more about how the gambling operation here looked almost exactly like the gambling operation from before?
That would have a higher value.
Right. Because then we start getting into what we're going to talk about in a little bit, some of the signature type crimes, right? But here, you certainly could argue that someone who knows how to, I mean, you could also, what's the other argument though for this, Richards? Have you ever done any gambling? Legal gambling?
Yeah.
All right, it's fairly involved. Well, I don't know if, I guess we won't get into this on tape. I'm not going to admit to anything on tape here, and I shouldn't ask you to. But if one has ever, I have a friend who tried to, this is true, this is absolutely true. I have a friend who was dead set on opening an offshore gambling account, and it was quite an involved process, right? And I imagine it's a fairly cumbersome, involved process to set up a private gambling operation too. Wouldn't you?
Probably.
Yeah, and if we had information about that, that would increase the likelihood that this is a smaller set of people. So the argument we were making the other day, if this guy knows how to engage in this kind of illegal gambling operation, doesn't knowing that put him in a small group of people who could have been engaging in this gambling operation. So at least it makes it more likely that he was the guy in that apartment. So you could make that kind of argument, right?
Yes.
And you made an argument earlier in the clip that I think would apply here. I mean, what's the real risk of prejudice from here to here?
I guess I think because he was a gambler, because he had the gambling ring, that he was more likely to have drugs.
Yeah, does that seem like the kind of inference that most people are going to make?
Probably.
Probably? Do you know a lot of drug dealers who also run gambling rings? Do you know a lot of gamblers who... So you do know a lot of drug dealers?
I can't say on tape.
Okay. Well, I guess here's the question. Do we necessarily think that people are going to draw the negative inference from the gambling to the drug dealing? That this is going to be, the person who would be an illegal gambler is the same kind of person who would be a drug dealer? I think the risk of that's not tremendous, but I suppose you could say this is somebody who basically doesn't respect the law. And I think that's Ulmer's kind of argument here, is that with both of these, you're basically putting on evidence that this guy is a criminal, that he has a criminal character. And that is certainly the argument that could win the day. The counter argument is, well, but we're not saying that he is this particular kind of criminal, and it's a very different kind of crime. And so the risk of the jury inferring from him being a gambler that he's also a drug dealer is fairly reduced. And that's why I think this will all turn on the probative value of the gambling on the identity question and what other means they have of establishing identity. If this is just one of 4 ways, what does it look like the government's doing if this is just one of 4 ways to link Jones to the apartment?
They're trying to make him look like a bad guy.
Yeah, exactly. And that should go out. If this is their only way, I think there's a real good chance it would come in. But you certainly could argue that even though it's not a character inference about drug dealing, it does require a character inference. 404A bars it. And so this evidence shouldn't come in. Right? Now what if we change this, Ulmer, and it's not gambling slips, but it is bicycling brochures, and he used to be a bicyclist. Right? And now we find in the apartment all kind, we like sweaty spandex shorts, right? Steroids, other doping mechanisms, right? Pictures of Greg LeMond all over the apartment. Right? He was a famous bicyclist. You didn't know that? All right. And they want to use the bicycling inference here, that once a bicyclist, still a bicyclist, as shown by the bicycling paraphernalia. That links him to the apartment. What outcome in that case? We still have a character inference, don't we?
Right.
What do you think the outcome is in this case now? This is, I hope he's getting this on tape, this beautiful diagram. It's so helpful, my scribbling.
I mean, it may be less of an issue because being a bicyclist doesn't usually have a bad character.
Wrong! How annoying are bicyclists? Right? Don't you, that's right, isn't it? Have you spent much time with Sprigman? I mean, that's just, you know, nobody should have to do that. Don't you just want to run them down sometimes? You're on tape.
No, never.
All right. They are fairly annoying. But is this the kind of inference that we're worried about under 404A? No, exactly not. Arguably, my beautiful diagram when it was gambling, where you're making an adverse judgment about the criminal or moral character, that certainly is the kind of inference we're trying to bar under 404A. Here, it's certainly a character inference. This is the kind of guy who is likely to ride a bike and be interested in bicycling matters. And I sincerely have negative views of those kinds of people, but is that the kind that we would expect most jurors to have? No, probably not. So what are we going to say here? The calculus is all different, right? And the reason I want to emphasize this, don't think of 404A and 404B in mechanical terms. And the advisory committee notes really emphasize this. You can put practically every 404B type of evidence into 404A. You can make a character inference argument. Each of these decisions about 404B evidence is really a 403 calculus. The court is trying to balance the probative value on the permissible purpose, like identity, against the risk of unfair prejudice for the other forbidden character inference. If that other character inference is about bicycling, love of nuns, well, that's a bad example, because that could be creepy, right? But I was going to say love of children either. Something that is nice, love of flowers, whatever. What's the risk of prejudice? Not a lot, right? So just keep that in mind when you're doing these. There aren't mechanical answers to these problems. The judge has to make basically a 403 balancing on every one of these decisions. Well, every one of these admissibility decisions, okay? Now let's look at some of the other uses of 404B, and one of the most, I don't know if it's interesting, but it's certainly one of the most common in criminal cases, is a case like Trinkler, where you've got the argument that someone's past crimes indicate the handiwork of this person in this new case, or that the person has committed a series of signature crimes, and this is just another example of his signature. Right? So in Trinkler, which by the way, I hope you found it a little frightening on how easy it is to find somebody to make bombs. Isn't that crazy? But on the other hand, they're not the sharpest tools in the shed. This is the guy who has the young kid go into Radio Shack to get the parts he needs for the bomb, and gets frustrated when the kid can't read his list. Oh, detonator. Sir, can you help me find the detonator? So he just goes in and helps the kid buy the rest of the things that are needed for the bomb, supposedly, right? In this case, Mr. Trinkler is accused of building a bomb for Mr. Shea Jr. to kill Mr. Shea Sr. It's a loving family. The bomb goes off and kills a bod squad member trying to defuse it. Trinkler and Mr. Shea Jr. are charged with murder. Trinkler admits that he built a bomb in the past for a different Miss Shea, S-H-E-A, to use to intimidate a business competitor. I think this was in like the Buffalo, New York area. These are some tough people, right? The government wants to use evidence that the bomb that Trinkler previously built was so similar to the one used in this case that that Trinkler has a particular signature for building bombs. Right? He makes bombs in a very unique way, and we can look at the uniqueness of the earlier bomb and this bomb compared to other bombs, and that will give us information about the likelihood that Trinkler made both bombs. This is sometimes also called modus operandi evidence, right? What is the inference here, Mr. Richards, that we have to engage in order to use this evidence for identity purposes, right? So we've got, I can't find a, we've got bomb 1, which Trinkler admits building. We've got bomb 2, which he denies, right? So we got bomb 1 that Trinkler admits to. We've got bomb 2, Trinkler denies. The court wants to put in evidence that Trinkler built bomb 1 and its similarities to bomb 2 to show that Trinkler built both of them, to show identity, right? So what are the inferences here that we need to make in order to have the relevance on identity? That this bomb helps establish Trinkler's identity as the maker of this bomb. And he concedes that he made this bomb, bomb 1.
I guess you have to assume that if you make a bomb one way, then you're more likely to make the bomb that same way in the future. And I guess there's a small class of people that make the bomb that same way.
Okay, so basically that these bombs are highly similar, so we need to establish that, right? Highly similar or alike, distinctive. And then there's something else. So we need to convince somebody that these were made by the same person, right? Because of the similarities. And we're assuming that a person who makes bomb 1 this way is more likely to make bomb 2 the same way, right?
Right.
I mean, that's got to be a required inference here. Why is that not a propensity inference? Isn't it?
I mean, I guess you could argue it's not a character trait, maybe?
But what is it then? I mean, we don't even have a good definition. I mean, this is one of the reasons I want to focus on this, is it really brings out the problem that we don't have a definition of character in the rules. There's no question in there that because you said it really nicely, we assume that someone who made a bomb in X way will make a second bomb in X way. So you are assuming that there is some propensity to build bombs in the same way, it seems to me. And I think you are on to the only way around the propensity problem here. What is the nature of that propensity inference that you are drawing here? Is it really something about moral character?
No, it's, well, not really, I guess. I mean, you could argue that a person who makes bombs is of dubious moral character, but...
Well, that's certain. Well, look, remember what we said. There is always in the background that inference could be drawn from this, right? The question is that the only way you could get these two bombs being built by the same person? Do you have to have an Dr. Evil? Do you have to have an evil disposition? You could just be desperate, right?
True.
You could be desperate and you did it one way and it worked. And you're simply likely, if you have success with a bomb one way, why mess with success, right? It didn't hurt the Unabomber for years and years and years. He used the same MO for a long time, right? So I don't think there's any way around the view when you're using this evidence for MO to establish identity or these signature crimes. I don't think there's any way you can say you're not making some kind of propensity inference here. The only way you can argue this is okay, and it's the way the courts have accepted, is that it's not necessarily an inference about the moral character of the person. It's really more of a generic inference that people simply are likely to repeat things that have worked in the past. Or people have patterns of ways. It's almost a habit type of argument, which we're going to come to later. It doesn't have to rise to the level of a habit, but it certainly involves some assumption of regularity in behavior. But you don't necessarily have to think that there's anything moral or immoral about that regularity, right?
Yeah.
I think that's the only argument you can make. It's the only one I've ever seen to establish that necessary inference from here to here. Now, There's one other problem, of course, when you've got these kinds of signature crime cases. How do we know they're actually highly similar, right? What if all we had was the bomb was made from dynamite? So we got Wile E. Coyote on trial, and bomb 1 was dynamite, bomb 2 is dynamite. Is that enough? Is that a signature?
No, I mean, dynamite, I think anyway, is pretty, you go out and buy dynamite and...
I don't think you can that easily, by the way, but I just want that clear, right? But you can get large amounts of fertilizer, which you can turn into a bomb, but don't do that either, all right? In fact, they do track large purchases of fertilizer, just in case you're thinking about doing that.
But it doesn't seem sufficiently unique to
No.
be able to draw an identity from there.
Right. I mean, if all they've got is one characteristic from this bomb that matches one characteristic on that bomb, and anybody making a bomb would likely use that, how distinctive is that? Can we say there's any real probative value from the first bomb for this bomb? No. No. Is there enough here? We've got the same general geographic location. Both use battery power sources. Both used round magnets. That was damning to me. They had I would have liked to know more about the distinctive method of connecting wires. I loved this one. This was one that the expert who actually, they were both homemade as opposed to off-the-rack bombs, right? He used the same method of using others to buy the products. They were both radio controlled as opposed to having really long fuses. Similar switches in the fusing circuits, and both were placed under the vehicle. Now the dissimilarities, one had a dynamite explosive and another had a flash device. They had different remote control devices. One had a single versus a double toggle switch, different size batteries. One had a wooden box housing for the bomb maker with pride, and the second bomb was simply duct taped together. So how do we decide if there's enough similarity there?
It seems like, it honestly seems like you'd have to see each of these things and kind of compare and see what they look like in order to determine if they're similar or not. I mean, it seems like you could probably describe them in opinion like this to be either similar or distinct.
Well, and the government's expert is highly motivated to find as many similarities as possible and as few dissimilarities as possible, right? So ultimately, what is the test the court should apply here in deciding whether or not to let the jury hear this? So let's go through that. What's the test here the judge should use in deciding whether or not to let the jury hear that Trinkler built bomb 1 and hear all about the characteristics of bomb 1 and how it was similar and dissimilar to bomb 2?
If there's sufficient evidence for the reasonable jury to find that Trinkler made both bombs,
Right, that the bombs were made by the same person, and there's no dispute that it was Trinkler on the first one. That's I want to emphasize, yes, that's the right standard under Huddleston, right? But the first step in that analysis should be really the 403, the 404B/403 analysis. The court first has to buy that there is a use under 404B, the probative value of which is not substantially outweighed by the risk of unfair prejudice. And once the court determines that there is a proper 404B use that could be made of the evidence, then it is exactly the analysis you performed. Is there sufficient admissible evidence that a reasonable jury could conclude by preponderance that Mr. Trinkler built bomb 1 and that it is similar to bomb 2? The jury doesn't have to buy that he made both bombs. There's just got to be sufficient admissible evidence that a reasonable jury could make that finding. All right? the simple rule for these signature crime cases, of course, is the more distinctive the crimes, and the more of them, the more likely the evidence is going to come in under an MO theory to establish identity. So if I kill my victims and carve PGM was here in all of them, and then there's a new victim turns up with PGM was here there in the torso, I'm pretty close to cooked, probably, right? That's why I always carve Sprigman was here in my victims, but that's another discussion, right? All right, let's change gears just a little bit. And the only reason it's where it is, the Stevens case, is because it's somewhat like the Trinkler case, but in a reverse pattern. And then we'll go back to some of the more traditional 404B uses of other crimes and acts evidence. So Stevens is an example where the defendant, the criminal defendant, wants to put on evidence of other acts committed by someone other than himself to establish his innocence on the crime charged. So Stevens was charged with robbery of 2 military officers and sexual assault of the female military officer. One of the officers identifies Stevens as the assailant in the first crime. The female officer is less sure that he was the assailant. They start investigating Stevens for another crime that occurs after the first one. The victim of the second crime said that Stevens was not the assailant, though. Subsequently, proceeds from the 2 crimes show up in another town, strongly suggesting, of course, that the crimes in question were both committed by the same person. And Stevens wants to put on evidence of this second crime and its connection to the first crime, for which the victim cannot identify him, to establish that it's unlikely he committed the first crime, right? So he wants to put in evidence that whoever robbed the second person likely robbed the first 2 people because proceeds from both crimes were intermingled. He used an ID from one crime to cash a check he obtained from the other crime. So there's strong evidence linking those 2 crimes, right? And he wants to put on evidence that he was not, that the victim of the second crime couldn't identify him, and evidence that the first and second crimes were linked through these proceeds, right? Should we be worried about prejudice to the defendant with this kind of evidence? Of course not, right? So we don't have the traditional 404A concern with this kind of evidence. Are we worried about prejudice to the prosecution here? No. They're not the victim. They're not the ones who committed the other crime, who are on trial here. So we don't, whenever we have, in these rare circumstances when we have it, this reverse 404B type of evidence, where a defendant is trying to use other act evidence to suggest that someone else committed the crime in question, the balancing is very different. Typically, the only question will be, is there really any probative value in this other act evidence, and would it waste too much time putting on this other act evidence? So if you find yourself representing a criminal defendant in one of these rare cases where you can use reverse 404B evidence, courts will typically accept it so long as you can show that it has probative value to establish that your guy was not the perpetrator here, and that it will not waste a tremendous amount of time in light of its probative value. In this case, this was crucial evidence, and it was very probative that he was likely not the assailant in either crime. So the court said it should have been allowed in this case. And in fact, it was harmless. It was not harmless error to exclude it. So if you find yourself in one of these situations, you are most likely going to get it in. You still have to pass the 104B hurdle, right? You still have to put on sufficient admissible evidence that the reasonable jury could conclude that this other act was committed by someone else. And in this instance, that other person was likely to have committed both of the crimes in question. But I think that hurdle was easily surmounted here. Okay? All right. Now, moving on, back on track to these more traditional uses of 404B, unless there were questions about that, since I raced through Stevens. Are there questions? No? All right. Then let's look at the Russian roulette problem 3.10 on page 178. So Ms. Barker, Height is charged with possession of a firearm that has an obliterated serial number that was found in a backpack in Mr. Height's room in his grandmother's house. Height claimed that the gun belonged to his cousin. Before trial, prosecution gives notice that it intended to present testimony from Height's ex-fiancée, I don't know why she's his ex-fiancée, Ms. Stewart, that 4 years earlier, Mr. Height had used this very gun in a game of Russian roulette with her, He showed her the gun, put a bullet in it, spun the chamber, pointed the gun at her head, and pulled the trigger a few times. Obviously not 6 or but she finally convinced him to stop. Height objected, of course, to this evidence. The trial court allowed Ms. Stewart to testify that she saw the gun, that Height put a bullet in the chamber and spun it, that he pulled the trigger to the gun, but doesn't get to explain to the jury the other context, that this was being pointed at her in this perverse Russian roulette love courtship. All right? Was it proper to allow this evidence in as it was? Why not just allow Ms. Stewart to say that she had seen the gun in Height's possession?
Well, I thought maybe it was along the lines of the old chief case where the jury might wonder what the circumstances were that she would have seen him with the gun.
Right.
So they were trying to develop a narrative, but to go all the way and say he was aiming it at her and playing Russian roulette might go over the prejudicial line.
So why? So she basically got to say she saw him put a bullet in the gun, do the trigger, not say he pointed it at me.
Right.
All right? Why? What does that add to the story? Spun the chamber, doesn't that leave a huge hole in the story that the prosecution wants to tell?
Well, it shows that he knew how to operate the gun.
Okay. Does that make it more likely that he owned the gun? Or possessed the gun? Maybe.
Yeah, I mean, he was in possession of it at that time.
Right. But why do you need to tell that part of the story? Just say she saw him with the gun, operating the gun. Why do you have to put in that he put the bullets in there?
Because maybe it makes it more believable that she really saw him and that he was mechanically knew everything that he was supposed to do.
All right. So you're good with the way that she was allowed to present her testimony, and you would say it had a proper purpose here to establish that he had possessed this gun in a previous point, right? And we didn't go, by doing it this way, we didn't go so far. What's the character inference the jury may have drawn from the way she testified?
The limited way she took?
Yeah, the limited way.
I guess they could have thought that he was a gun aficionado, you know, like he liked to play around with guns. Which
Right.
is not good, I guess.
Well, depends
But
on,
as
it's not
bad
bad.
as pointing it at a person.
Right, so the court basically split the baby here and did it in a way that you think achieved the prosecution's purpose without doing too much prejudice to Mr. Height.
Yes.
Now, what's the argument for telling them that he put the gun up to my head? What's the prosecution argument for that?
For getting it in?
Yeah. Think about that. Hurry.
Because that shows that he's kind of reckless with life and
Well, that's not part of the charge, though. He's just a fellow. He's just in possession of a gun with an obliterated. You're not supposed to do that, by the way. You're supposed to leave the serial numbers on the guns. Obviously, they were investigating the guy for something else too, but this is one of the charges. So why would the prosecution say we get to tell you more? We get to tell you why he was pointing at him. Is there an argument that they should have been allowed to go further? Because the story you told me did not seem like much of a story. I don't even know why we have really, under the story you accepted, which I think you made a good case for that evidence. But I don't even know why we have 404A concerns with that evidence, really. It just seems, the risk of prejudice seems very slight. If I'm the prosecution, I want to say that he engaged in Russian roulette with me.
well,
And what's the argument for going that next step? That's what I'm trying to figure out.
I guess maybe if you obliterate the serial number on your gun, perhaps you're up to criminal activity, and this kind of shows that maybe he has the capacity to do some criminal stuff.
What if Height says, you know, women, they get all nervous around guns. She's mistaken. That was not the same gun that she saw me operating.
Well, she could say, I saw it pretty up close.
But now, she didn't say that the first time, right?
Right.
So is that the argument for going all the way here about what happened with the gun? She doesn't have to say Russian roulette. We'll let them figure out Russian roulette. Do you have a better view of the gun when it's being pointed at you and the trigger pulled? I would think so.
Yeah, maybe, but you might have a better side view of it.
You might also be nervous when it's pointed at you, right? Like every time I get close to you, you seem to be looking away. Did you notice about my fingers?
No, I hadn't until just
See? So maybe the argument, you obviously would be a terrible witness, right? Did you notice what I had there? Yeah. Well, you weren't the one with the gun pointed at your head, were you? Right? I wrote on there that you are a terrible witness. I can't believe I called on you. No, I didn't. I just wrote yo on there. I thought she would see that. I thought you just blew the demonstration for the tape. Way to go. I thought you were going to say, well, and then I could notice that you had yo written on your fingers.
Well, yeah, but when it's
But then didn't you make the defense's point? That when you're under these circumstances, it's just as likely that you wouldn't notice it because you're nervous and you're all excited and yeah. So I mean that's the counter argument, right?
yeah.
Did I frighten you? Well, the argument, this is supposed to illustrate the narrative or res gesti argument for other act evidence. But I actually think, Barker, you actually did demonstrate how it's a little bit silly to think in this case adding that additional detail would have done much. So the prosecution's argument here was we needed to be able to tell them more the specifics about how this occurred, that she had the gun pointed right at her face and it was clicked at, the trigger was pulled as this threatening part of Russian roulette so that the jury could appreciate how likely she was to have really clearly seen this gun and remembered this gun. So they were unhappy with the ruling where they couldn't tell all of the information. And the argument was, you can't appreciate why she would have such a clear memory of the gun without understanding all of these details. So it was the narrative argument you were making. But I really do think in some ways you illustrated that argument could be BS, because we don't really know that that didn't actually make her more nervous and less attentive to the details. In fact, there's quite good evidence from eyewitness research that the presence of a weapon degrades, this is in general, not always, but it actually degrades eyewitness testimony because it, from the face, now this research has been, can you identify the face of someone with a gun? Not as well as someone without a gun because it distracts you. So you could argue that this would have been more distracting, but the prosecution was trying to make the argument that you needed to know about the full gunplay here to better appreciate what a clear view and memory she had of the gun. And this is an example of the res gestae or narrative integrity use of other act evidence under 404B. So the idea here is, that the jury should hear about other acts that are either inextricably linked to the crime in question, so that they get a proper understanding of what transpired, or they should hear about other acts that are needed to complete the story the prosecution or the other party is trying to tell in the case. A great example of the second use of the res gestae doctrine under 404B is the United States versus DeGeorge case. This is this amazing case where DeGeorge was charged with mail fraud, wire fraud, and perjury in connection with his alleged insurance fraud on Cigna. Mr. DeGeorge had bought an Italian yacht for $1.9 million. He engages in sham transactions with supposed corporate entities that he really controlled, and they weren't real corporate entities, under which these corporate entities supposedly bought the boat for $3.6 million from DeGeorge, but of course no money ever changed hands. Then the corporate owner takes a policy out for $3.5 million on the yacht in question. So all of these transactions were to get the supposed value of the yacht up for insurance purposes, right? And then Mr. DeGeorge and his conspirators take the yacht out into the ocean and proceed to try to sink it without any success. And the Italian Coast Guard, or whatever they're called, the Italian Coast Guard, it's probably the same people with the Concordia, right? They tell him to get back on the damn boat. And he says, well, wait, we were attacked by a crew of pirates who tried to sink our boat, and then inexplicably, without taking anything from us and without taking the boat, left. It's the most ridiculous, fantastical story ever. Nobody buys it. Mr. DeGeorge is being prosecuted for insurance fraud, and the question in this case was whether the government could put on evidence that DeGeorge had previously lost 3 other insured vessels at sea. There was no evidence on whether fraud had occurred in those cases. They weren't going to necessarily claim fraud, but they wanted to tell the jury about these other 3 vessel losses. Why? Obviously, the jury might draw the inference that this is the kind of guy who engages in insurance fraud, right? But their argument was the jury wouldn't be able to understand why DeGeorge engaged in this convoluted scheme to have these corporate entities buy the boat unless they understood he couldn't get insurance in his own name due to these 3 prior losses. The court accepts that use of the evidence under the theory that this evidence was needed to complete the story the prosecution was telling to the jury so that they would understand how all of the evidence fit together. It did not think that the 3 prior losses were inextricably related to the conduct involved in this case because they were so remote and distinct in nature, but it did think that they were necessary to complete the story, so they were admitted under this narrative integrity rationale under 404B. So the 2 ways you can use this theory under 404B is where some other act is just inextricably related to the charged conduct. So maybe you have somebody who's on trial for kidnapping someone, and you have to explain that that kidnapping occurred in the context of a bank robbery, right? They kidnapped this person because they were trying to get away from a bank robbery. That would be an example where you get to tell them about the bank robbery to explain how the kidnapping occurred, because those 2 acts are inextricably related. The bank robbery led to the kidnapping. Another instance, the other use is to complete the story rationale, like in DeGeorge, where you have to tell them about 1 act so they can understand all of the evidence relating to the charged act. Okay? All right, we're rocking along, so let's do another problem here. So Barker. Now we've got the cleaning the gun problem 3.11, where the defendant is accused of shooting his wife. He testifies that it happened accidentally while cleaning his gun. All right? Prosecutor offers evidence that the defendant had earlier shot and killed his first wife. That in that instance, the defendant claimed that he was simply cleaning his hunting rifle when it accidentally discharged. Should the judge let evidence of that prior shooting in on this case, the second shooting case where he claims it was a mistake or an accident?
I think it should, because, for the prosecution side, it seems highly unlikely that that would happen twice. That he would have 2 wives killed because his hunting rifle discharged while he was cleaning it.
Why is that? Have you ever cleaned a hunting rifle? Is it because you're saying it's easy to clean a hunting rifle? It's not.
I mean, my dad is a hunter, and he's cleaned his gun several times, and I don't think it's ever accidentally gone off.
But I think you're saying something other than that, though. What if your dad had accidentally one time shot you in the leg while cleaning? Jesus, Dad! You could be vice president! Right? Please. I can't believe I get a groan on a Cheney joke. My God. All right, anyway. All right. You're saying something more than it's just unlikely that the gun will discharge twice accidentally and kill someone, I think. Aren't you? Let's say let's reverse, let's get out of these sex stereotypes, which I hate, as you know. All right? And let's say that you have the gun and Mr. Schneider is your husband the first time, and you accidentally shoot him while cleaning your hunting rifle, and you get all his insurance, life insurance, thankfully. All right? And then you marry Kumar, right? And you're about to clean your gun. Let's say you really did the first time accidentally shoot Snyder. And now you've got Kumar as your loved one, and you're about to clean the gun. What are you going to do this time?
Probably go somewhere where my husband's nowhere to be found.
Honey, I'm cleaning the gun. Leave the house. Put on your vest, your bulletproof vest or something, right? I mean, isn't that what you're really getting at? Do we expect someone who has once killed a loved one accidentally to conduct themselves in the same way with respect to the exact same kind of event after that's happened? And so if it happens twice, what does that say to us? What is that telling you?
It was probably done on purpose.
Right. So you're wanting to use this evidence to dispute his claim that he did not have the intent necessary to commit this crime because it was an accident. And the reasoning, the inference there is really, I think, simply this idea, very similar to the doctrine of chances idea that's talked about later. How likely is it that these two events would have occurred accidentally?
I think very unlikely.
Right, especially given the first one. You want to use that, you want to give that evidence to the jury so they can make an assessment on whether someone would have continued to act in this reckless way after the first event. And so if he puts into issue his intent here and claims it was an accident, I think you should be allowed to put on this evidence of the prior accident. He can still say it was an accident, but we don't really care. I mean, you could argue we don't need to make any character inference. All the jury needs to know is that it happened so they can assess whether it was likely the second one happened by an accident too. What would a reasonable person have done after that first accident, right? What's the counter argument? What are we really doing here?
I guess the counter argument is that you're prejudiced. You're making the jury have the feeling that,
He's a wife killer.
yeah,
Yeah, right?
you made my argument.
Yeah, well, I mean, that's what you were getting to.
Yeah.
So, yeah, I mean, I think there's no question there's a big risk of unfair prejudice that they'll think this is the kind of guy who just likes to kill his wives when it's convenient to do so, right? So we would have to ask ourselves, what's the risk of that, of the jury using the evidence only for that purpose versus for the purpose of assessing how credible his story is about how he conducted himself here and whether an accident really occurred. Let me give you a different example. I think it's a little more compelling. Let's say that I own a horse and I catch you with my horse. And you say, "Oh, Professor Mitchell, I'm sorry. I thought that was my horse." And then it turns out when I look over, you thought that, how did you think that was my horse? Oh, I just made a mistake. And I look over and there are 9 other people standing next to me, and you say to each one of them, "Oh, I'm sorry, I thought that was my horse." So you've got 10 horses where you supposedly made an accident, right? How likely do we think it is that you made 10 accidents here versus that you had an intent to steal the... You back on? Sorry. Yeah. Now, what kind of inference are we making there? Are we making a character inference about you as a general thief?
Yeah, or as a liar.
Well, but aren't we, all we really having to do is say, you know what, her story holds no water here. It's much more likely that she was intending to steal these horses, right? So no, we don't even really have to make any general inference about why you did that. I mean, it may be that you need 10 horses fast for something. You're a wonderful person. You're going to ride them, give, drugs to the needy. That doesn't make sense. I mean, prescription drugs, whatever, right? We don't have to make a general inference about your moral character there, right? We're simply using that evidence to assess the likelihood that your accident account is true here. So the more instances of supposed accident that share this, that seem to all share common characteristics, the less likely that the jury is going to make a general character inference, and they're simply going to use the evidence to test the likelihood that all of these were accidents or mistakes, right? That is really a form of reasoning that is also found under the doctrine of chances, which was discussed with a wonderful case, wonderful to us, not to Miss Mundy, Rex v. Smith is a famous case where Mr. Smith is accused of drowning his new wife, Miss Mundy, who just happened to have inherited money recently, who just happened to fall in love and marry Mr. Smith within a very short time period thereafter, and execute a will to him in that time period, and who just happened to start experiencing fits, according to Mr. Smith, and who just happened to have one of those fits in the bath that led to her drowning, according to Mr. Smith. Okay? It turns out that there were two previous moneyed wives of Mr. Smith who drowned in the bathtub under similar circumstances. The court here allows the evidence in on the theory that that's come to be known as the doctrine of chances, that those three events were highly unlikely to have occurred by coincidence, so that the jury should be allowed to hear about those two prior incidences so they can assess the truth of Mr. Smith's claim that this was a pure accident here, right? So it's very similar to the cases we were talking about. And the idea here is that the defendant's connection to the events is not just coincidence. It must have been through some intentional behavior by the defendant that these three incidents occurred. Right? Do we have to draw a general character inference or an inference about Mr. Smith's moral character to conclude that he was likely to have committed all three drownings? No, I don't think so, do we? I think all we have to do is assess the likelihood of Mr. Smith being married to three women who drowned in this exact same way, right? So when you've got a case where it appears that the chance of these events occurring in this way and being connected to the defendant were all just coincidences or due to bad luck, if that risk is very, very low, then the court will employ this idea within the doctrine of chances that we will allow the opposing party to put on evidence of these similar other occurrences and let the jury decide whether or not they indicate that this defendant had engaged in a pattern of activity and that the current crime was simply an extension of that pattern. Right? And the idea here is you really don't have to make any specific character inferences. All you have to do is assess the likelihood that these events would fortuitously or randomly occur. Now, I don't think there's, Rothstein, if you did all of the reading, you saw Rothstein who says, any way you slice the doctrine of chances, it goes through the propensity box. And I think he's right. But I think it comes back to the discussion I was having with Ulmer and Richards earlier. We have to ask, what kind of character inference is really being implicated here? If this were an argument that he had one wife die under very different circumstances and he likely killed her, then we're probably drawing an inference that he just likes to kill his wives. If instead we're just having to assess the likelihood that these three chance events would occur and be connected to him, arguably all we're having to do is assess the likelihood of those three events occurring together. And so you're not necessarily having to assume anything particularly about his character. But I will concede, I think there is no question the doctrine of chances implicates character in much the way the problem I discussed with Ulmer and Richards about the gambling and the bicycling. I think it does implicate a character inference, but how bad is that character inference? I don't know, right? But here's the takeaway on the doctrine of chances. If you've got a a series of prior events that are highly similar to this one that seem to strongly indicate the defendant has engaged in a pattern of activity, it is almost certainly going to come in under the doctrine of chances. And in this case, by the way, after that evidence came in, it took the jury 10 minutes to convict Mr. Smith. So it was seen as highly probative of something, if not his character, then certainly his plan to defraud these women and kill them and take their money, right? Okay, so we'll stop there. We'll talk about Huddleston at the beginning of class. We won't take very long. And then we will talk about rules 413 through 415, these rules that expressly allow evidence of character in child abuse and sexual assault cases. Okay, so go on and read that. Thank you for being good sports today.